Hi, my name is Chelsea Sinclair, and I am a staff attorney at Northwestern Legal Services. And this video is going to give you a general overview of the custody procedures in Pennsylvania. If you want to file for custody or to modify a custody order, you can find custody packets for each county served by Northwestern Legal Services on our website. And these packets include petitions and instructions on how to fill out these packets and file them with your county. And each county has different forms, so make sure that you're following the instructions and filling out the petitions for the correct county. We're going to start with some general information on custody. First and foremost, both parents have a right to have a relationship with their child. And a child has a right to have a relationship with each parent. And it's usually best that the parents agree about how to share custody of the child. But if you cannot agree and you file a custody complaint, then you will be leaving it up to the judge to determine what's in the best interest of the child. Also, custody and child support are separate issues. So if the other parent fails to pay support, then you may not refuse to allow contact between the parent and the child. Likewise, if a parent refuses to allow contact, you may not stop paying your child support. Now, let's talk about what happens if you don't have a custody order. First, what you should do is decide whether or not you should file for custody or not. If there are no problems between you and the other parent, if there are no threats to the child, or even if there have been no visits between the other parent and the child for a while, you may not need to file a custody complaint. But if you and the other parent are not agreeing on custody, or if you fear that the other parent will take your child and not return your child, then you should consider filing a complaint at that point. When a person files a custody complaint, there are two different types of custody rights that a court will deal with. The first type is called legal custody. And what legal custody is it's the right of a parent to make major decisions on behalf of the child. This includes decisions like education, medical, dental care, religious upbringing. This also includes who has access to medical records, school records, and things like that. Legal custody can be granted to one parent, or it can be granted to both parents. The other type of custody that the courts will deal with is called physical custody. This means who has physical possession of the child and when. There are several different types of physical custody, so I'm going to go over some definitions that you should know. The first is shared physical custody. And that is the right of more than one individual to have physical possession of the child for significant periods of time. Next, primary physical custody is the right of a parent to have the child for the majority of the time. Partial physical custody is the right of a parent to have physical possession of the child less than majority of the time. There's also supervised partial custody, which is custodial time during which an agency or an adult designated by the court or agreed to by the parties monitors the interaction between the child and the individual with those rights. And finally, there's sole physical custody, which is the right of one parent to have exclusive physical custody of the child. Now, to begin the custody process, either you or the other parent must file a custody complaint. A complaint is documentation that basically asks the court to decide who has legal custody and who has physical custody of a child and when. In the complaint, you will have to provide information about yourself, about the other parent, and about the child. You'll also have to indicate what kind of custody rights you are looking for and why it's in the child's best interest that you be given the rights that you're asking for. Along with a complaint, you'll now have to file a criminal history abuse verification form, and this must be filled out by both parents. On this form, there will be numerous criminal charges listed, and you will have to indicate whether you have been involved in any of those charges. You'll also have to indicate if you've had any PFAs against you or any findings of abuse from CYS. You have to indicate whether you had any of those listed items or anybody in your household as well. You must be truthful on these forms, or there's a penalty of a fine. This criminal history form should be filed at the courthouse when you file your complaint. When you go to file your complaint, you should consider where to file it. You have to file the complaint in the county where the child has lived for the past 6 months. If the child has not lived in the county for the past 6 months, then the court does not have the authority to make a decision on custody. You can file in a county where the child is residing, even if it has not been for the last 6 months, only if you can show that filing in the county where the child has lived for the past 6 months would be inconvenient. For example, if neither you or the other parent live in that county any longer, or if it would be in the child's best interest that you file in the new county. When you file a custody complaint at the courthouse, there will be a filing fee. You will have to pay this fee if you can afford it, but if you cannot afford this fee, then you should file and fill out a petition to proceed in forma pauperis. This is a petition that asks the court to waive the fees associated with filing a custody complaint. In this petition, you will have to fill out specific information about your financial condition. A judge will review this petition and decide whether the fees in your case can be waived or not. Now, once you file the paperwork, the procedures from here vary county to county. But what's important is that once you have a court order determining custody, you must obey this order, and the other parent must also obey this order. It is enforceable by the police or by filing a civil contempt action. A lot of times, if parents are getting along, they will write out an agreement themselves and sometimes have it notarized, but this cannot be enforced by the police and it cannot be enforced by the courts either. A lot of times, if parents are getting along and agree to the custody rights of a child, they will write out the agreement themselves and sign it and sometimes have it notarized, but this cannot be enforced by the police, nor can it be enforced by the courts. If the other parent is not following the custody order, then you should keep track of the incidents and notify the other parent in writing that you expect them to follow the order. If they still do not obey the order at that point, then you should file a civil contempt. Basically, a civil contempt would be you asking the court to tell the other parent that they have to follow the order, or the judge can punish them in a variety of ways. Now, if you have a custody order and circumstances change and require a change to the order, you should file a modification. In the modification petition, you will need to explain why the current custody order needs to be changed. If it's a temporary change, like altering weekends for a family reunion, then you wouldn't necessarily need a modification. But if the change is more permanent, then you should file a modification at that point. If you do want to file a modification, there are petitions and instructions on how to fill out the petitions on our website for each county. Now, in some circumstances, there are people who are not the parents of a child, such as an aunt, an uncle, a grandparent, or a family friend, who believe that the child would be better off if they had custody and not the parents. In order to file for custody, for a third party to file custody, they would have to show the court that they have been acting in loco parentis. In order for someone to show that they have been acting in loco parentis, this person must show the court that he or she has assumed physical custody of the child and has been acting in a parental capacity towards the child. Grandparents can also ask for custody under Pennsylvania law through the in loco parentis, just like any other third party, but Pennsylvania law also gives grandparents more rights than third parties to request partial custody of a grandchild. Grandparents have the right to partial custody of a grandchild if either one of these following conditions exists. Either the child's parents are separated or divorced, or the parent of the grandchild is deceased, or the child has lived with the grandparents for 12 months or more, and the request is filed within 6 months of the removal of the child from the grandparents' care. Now, just generally, anytime a court is making a decision on custody, the court is going to look at what's in the best interest of the child. There are 16 factors that the court will look at, and I'm just going to go over some of them. For example, the court's going to look at which party is more likely to encourage and promote a relationship between the other party and the child. The court will look at any abuse history of the parents. The court will look at what each party does to parent the child. The court will look at the child's need for stability in the community, education, and family life. The availability of extended family will be important. The child's preference will be taken into consideration. Also, any history of drug or alcohol abuse between the parties, and the mental and physical condition of the parties as well. And those are only some of the factors. There are many more, but those are the highlights of what the court will look at when deciding what's in the best interest of the child. Those are some general points on custody and how custody works in Pennsylvania. And again, if you want to file either a complaint or a modification, the petitions and instructions for the counties we serve will be on our website.